And there we go. All right, Paul Sponcia, CEO of the IT company, working in the comfort of my home under COVID-19 pandemic stay-at-home orders, as all of us. And I'm here with my friend and my attorney, from a business perspective, John Wood. And I'm going to let you tell everybody who you are and who the firm is and kind of what your specialty is, and et cetera.
Okay. Yeah, my name's John Wood. I'm with Egerton McAfee here in Knoxville, Tennessee, and we are a general purpose law firm that represents businesses like Paul's in all types of matters, from litigation to transactional matters. My background is specifically in software. I have an undergrad and master's in computer science. I worked for an extended period of time in the software industry before I went to law school. And so my practice has focused around assisting technology companies, software companies, and then with licensing issues, software, technology, do a lot of trademark work, copyright work, those types of things. And also general business work as well, but my specialty's in the IP area.
Yeah, I think you're as we've got to know each other, your background is interesting. As you went to law school as a not as a youngster.
Right. Right. Exactly.
As an adult with a family.
Yeah.
So pretty cool. So we're here to talk about this. I joke this term called force majeure, which I think most of us have probably seen in our contracts and probably been like, yeah, what's this thing in there? It looks like a French word.
Right.
And I see some stuff in there, but I mean, when's it ever going to be useful? Well, here we are. Pandemic. A lot of people are now paying attention to this clause in their contracts. So maybe you could give everybody just what the heck is force majeure?
Sure. So force majeure is designed to allocate risk when there's an unforeseen act, like a pandemic. Usually you'll see a word in your force majeure clause like act of God. So a tornado, a hurricane, something that when you entered into the contract, you didn't foresee as prohibiting you from performing under the contract. And so the purpose of the force majeure clause is to say, if this happens, I'm excused from performance. Mm. That's what you're trying to do. And that can benefit, both parties, or it may only benefit one party.
Mm-hmm. So excused from performance, does that mean, because this happened, can the contract be canceled, or is it you can't cancel the contract, I just can't be held to the standards of the contract? Is that kind of the idea?
So it's a contractual term, and you could have a force majeure clause that says if this condition continues for so long, then I can cancel the contract and I no longer owe you money under the contract and we can continue. You have force majeure clauses that say for whatever period this happens, the contract is then extended for that amount of time on the back end.
Okay.
Or your most common force majeure clause kind of leaves it ambiguous and just says performance is excused for the period of time that this happens, and I'm not held liable. So it really depends on what your contract says. Because it is just a contractual term that's allocating risk between the parties.
Yeah, interesting. So here we are, COVID-19, nothing that probably anybody except for Bill Gates was thinking about as a potential thing to take place, and other people too. Does it apply? Are people trying to use it? Does it apply right now? Is it something that people are pulling their contracts out and saying, oh, here we go?
People are pulling their contracts out, and people are looking at this clause and trying to figure out if it relates to them, because all of a sudden they may not be able to operate their business. Mm-hmm. And so, the first thing you see is people don't want to pay their rent. They're like, I can't get into my business,
Good one.
then I
Yeah.
don't want to pay my rent. And like I said, it really depends on what your contract says. So we have had clients um, that have received that are landlords that have received letters that's, where the tenant says, hey, I've been ordered to not operate my business, so I'm not going to pay you rent for this period of time, and we'll extend the contract on the back end. Now, in many cases, the contract doesn't allow for that. And actually, if you're signing a contract written by a landlord, probably what the contract says is that the landlord is excused from providing you from performing, which means providing the property to you in the case of a force majeure event like a pandemic or an act of God, anything that's unforeseeable. So if you're the tenant and you have an agreement that's written in favor of the landlord, you may not have as much relief as you might think. Now, the landlord may just choose to defer your rent for a couple of months just to help you out, but it may not be required to under the contract. On the other hand, if you have a contract that says, in the case of a force majeure event, I cannot operate my business, I don't have to pay you rent for that period of time. I'm excused from my performance of paying rent. If that's what your contract says, then you should write your landlord a letter and say, hey, I don't have to pay you rent. But most landlords' forms, if you just sign their form, are not going to say that.
Yeah, that's interesting. Well, I think the good thing, this has nothing to do with the contract, but the good thing right now is that we're not in a situation where people are just not paying rent because they have a bad business. I think everybody realizes, at least what I've seen is everybody realizes, hey, we're better off trying to sort this out together and make sure you're a tenant for the next 5, 10, 15 years, instead of trying to play hardball right now, which is good. It's really good.
Right. That's what I've seen also is, this is an opportunity to build a lot of goodwill with your tenants, with whoever you have a contract with, and be reasonable. And then they'll treat you right on the back end.
That brings up a good point. So what if I don't have it in my contract? What if force majeure is not explicitly listed in a contract?
So there are statutory provisions that essentially provide the same thing in some cases. So all sales of goods are governed by a statutory provision called the Uniform Commercial Code, which is adopted in every state. And the Uniform Commercial Code built in has a provision, it's UCC 2615, excuse by failure of presupposed conditions. So, and again, this only applies to goods. So in other words, if you were under contract to provide a certain number of goods by a certain date and sell them at a certain price, and all of a sudden your factory closes and you don't have a force majeure clause, you probably can rely on this UCC clause, which says delay in delivery or non-delivery in whole or in part by a seller who complies with paragraphs B and C is not a breach of his duty under a contract for sale if performance as agreed has been made impracticable by the occurrence of a contingency, which was a basic assumption on which the contract was made. And so a basic assumption would be that I'm allowed to operate my factory whenever I want to operate my factory, right? Yeah. There was no basic assumption that neither party assumed that, in March of 2020, my business was going to have to shut down and I wouldn't be able to make my widgets, right? So if you have a contract, so even if you don't have a force majeure clause, if you're selling goods, you may have some statutory help. And then in some states, it's also built in just the general civil code, which would go beyond goods. So California has a statute that excuses performance prevented or delayed by an irresistible superhuman cause.
Wow. I love it.
Right? Yeah. So
Irresistible.
this would be Avengers kind of stuff, right?
Yeah.
Yeah. So if the aliens come in,
Yeah.
but I think a pandemic, forced closure by the government would potentially apply there. So
Yeah.
there's, even if you don't have a force majeure clause in a contractual remedy, you may have a statutory
What
remedy.
what if you have a contractual remedy that's not as good as the statute, meaning which one supersedes? Like if I have one that is very pro the opposite, but I'm the one being suffering as a result of it, does the statute pick up, or is it no, whatever's in your contract kind of supersedes it?
Well, if they conflict, then your contract may govern.
Got it.
But a lot of times what you'll have is a one-sided force majeure clause, and then the statute may help the other party.
Okay.
Yeah,
All right.
is really what you would have. So I think there's some relief even if you don't potentially have a force majeure clause.
All
And
right.
another thing I want to point out about force majeure clauses is it's hard. I mean, a few force majeure clauses had epidemic or pandemic listed in them. I think yours actually does, Paul. So,
Does have a good lawyer.
Yeah. But it's hard to foresee every potential thing that's going to come down the road, and so foreseeability is a big deal because usually it says or any unforeseen event.
Yeah.
So one thing people need to keep in mind is that this year, COVID-19, a pandemic, is an unforeseen event. Next year, it probably isn't.
Yeah.
Right.
Yeah.
So if you enter into a contract next year, everyone should adjust their force majeure clauses to include pandemic, epidemic, closure by the government, the things that have happened this year.
That was going to be my question. So you're an attorney. People are going to be coming to you and saying, "Hey, this happened." Everybody, once we get through whatever is next, whatever that looks like, people keep saying back to normal. I don't think we're ever going to be back to whatever, just a new normal. I think good businesses, I'm in this case of thinking through this, are going to think back through and say, all right, so we went through it. I need to update my policies and procedures. I got to go reevaluate my crisis management and, all these different continuity of operations.
Right.
One of those things is going to be contracts, and this is going to be an area where people are going to want to pay a lot of attention. So what do you think is going to, do you think anything substantial will change in that as you go advise people?
I think people are going to look at their leases a lot more carefully, and the clause that says, the landlord is excused from everything based on a force majeure clause, and the tenant always has to pay. People may start to negotiate that a little bit harder.
Yeah.
And then even any kind of service business where you've got to deliver a service. I mean, what if you have to shut down and you can't deliver your service, or you can't get into the building to deliver the service?
Yeah.
How people weren't thinking about that before. I think some lawyers were.
Yeah.
But business owners weren't.
Yeah.
They didn't think it was important because it would never happen because it's never happened to them. Now all of a sudden they're like, well, what if I actually can't perform under this contract? How are we going to allocate the liability on that? Do I still get paid? Should I be able to get out of it?
Yeah.
That kind of thing.
One of the things that we've been evaluating just as a company, as this started, I started thinking about this about 10 weeks ago when I first started hearing about it, and I got a little bit more serious probably 5 or 6 weeks ago is, I think what people don't think about that thankfully here did not happen is if we run a small business and 50% of our workforce came down with COVID-19 and couldn't work, what do we do? And so we're putting contingency plans in place with our peer group members and partners to kind of pick up as part of our business continuity and continuity of operations plan, and obviously force majeure is a component of that if we had to, but nobody wants to get to that point. You and I have talked about this a lot. Like, you have a contract, but you just don't want to get there. Like, you don't want to have to do that. So having a bit more of a plan in place is the key piece of this. Force majeure is great. It's there. It's in place. Make sure you do a good job with it to mitigate risk and protect yourself, but you got to focus on continuity of operations more than anything else.
I agree. Making sure you can still operate is a lot better than having to fall back on a force majeure clause. Because if you're having to do that, that means things are really bad, and you're not able to do what you need to do.
Yeah. Has it ever happened before? Have you ever? Is there examples where it's been enacted or utilized or whatever the word for it is?
Probably the only example of a quarantine in the U.S., or at least the last example, was the 1918 Spanish flu. And I did look at a case from then, and like I said, force majeure most directly applies to the delivery of goods. So it's Citrus Soap Company versus Peet Brothers Manufacturing Company. And so Citrus Soap had an agreement to supply Peet Brothers Manufacturing with glycerin so they could make soap. And they were supposed to supply them with a lot of glycerin. And they were providing it. So Peet Brothers agreed to buy it for a certain price, and Citrus Soap agreed to provide it by a certain date. So they were going to get their money. Peet Brothers can make their soap and meet whatever requirements they have. Well, right in the middle of that, this was in California, the San Francisco closed their factory, closed the Citrus Soap Company's factory, and said, sorry, you can't manufacture soap right now because we have the Spanish flu. Everybody has to go home. There's a quarantine. We're doing social distancing. They probably didn't call it social distancing then, but they had a quarantine. They sent everybody home. So there was no way they could manufacture the soap. And they were supposed to provide it by December 21st. They were able to provide it by January 9th. So they didn't miss the date by that much. Peet Brothers refused the shipment, said, you're late, I'm not paying you. Sent it back. And so Citrus Soap Company refused and said, you have to pay me. Now, the interesting thing is, in the meantime, the price of soap or glycerin had dropped by a third. And so what Peet Brothers was really trying to do was get out of their contract to pay.
Got it.
But Citrus Soap Company relied on their force majeure clause, which said if there's an act out of our control, then we're excused for performance during that time. And the court found for them and said, no, Peet Brothers, you owe them the money for the soap. You had a contract to buy it, and there's a clear force majeure clause in here that says if there's something unforeseeable, then they're excused from performance for that time. So, and they found that, they made all the efforts. A big part of the analysis is, just because the event happened, were you really precluded from doing what you could do, right? Had you done everything, like, did they ramp up immediately afterwards?
Right.
Could they have still made the date, right? So they weren't that late. They were a couple of weeks late. And it seems obvious Peet Brothers was trying to get a deal. They had made a bad contract. They had agreed to buy for a higher price. Yeah. And now, because of all the economy got all messed up, prices dropped, they wanted a good deal, and the court didn't let them out of it.
Wow.
Yeah. So in that case, the Citrus Soap Company was able to use their force majeure clause to enforce the contract and get paid, which was good result. Good result for them.
One thing I heard in there that I think is pretty interesting that I would imagine, again, I'd be really careful here. I'm not a lawyer, but the thing that I think about is, you said something that's important, is you can't just not perform because there's an event and you have force majeure. It's not like, event, force majeure.
Right.
It's like, you still, what you said was, like there was some requirement to attempt to perform. It wasn't like you could just be like, they shut us down, we're done, we're not going to try anything, whatsoever. So it sounds like there's an element of that where the courts might look at it and say, well, did you at least try to do, the best you could to offer the services, and versus just being like, I think about restaurants, a lot of, my wife owns 2 restaurants, and
Yeah.
a lot of restaurants have worked very hard to continue to operate and maintain, and, et cetera, where they've made an effort versus just being like, oh, well, sorry, we're just going to shut it down and call it quits.
Right. And as you know, and for a lot of businesses, you can work from home. Maybe it's not convenient, but with our technology. And so it really wouldn't be acceptable to just say, oh, we work in the office, we don't like working from home, so we're not going to provide our people with computers. We're not going to set up a VPN. We're not going to, we're not going to set up any kind of infrastructure to allow them to work from home. So we just can't perform any of our contracts during this time.
Right.
Right. If you have the ability to do it another way, you need to do that.
Right.
So yeah, you can't just use it. You can't use it as an excuse. That's not going to work, because the other side is going to try and say, kind of like Peep Brothers did, say, well, they could have made it on time. They just didn't try.
Right.
They were using an excuse, and their factory was closed. They couldn't do anything. So they had a pretty good excuse.
Yeah. Well, I pulled mine up since you mentioned it, and it obviously disclaims all this stuff, but I can't be like, oh, well, pandemic, we're just, it's not going to provide services. Don't worry about it. We'll get back to it when the restrictions are lifted. No, we have done everything possible, because I never actually want to deal with this clause. I don't ever want to. Obviously, if push came to shove, you'd want to use it as a risk mitigation tool, but I don't want to get there. I want to do everything I can to keep a viable operating business, support my clients, serve my clients, et cetera. So I think that's an important note for sure.
Yeah, I think so. And I think it builds goodwill in the future. If you supported your clients during this, you're going to support your clients during anything.
Yeah.
It's what they're going to think. And if you just shut down, they're trying to operate their business. They need your help.
Yeah.
Right?
Yep.
And
right.
So I think it does build a lot of goodwill.
Yeah. Well, we're getting to the end of our time. Are there any other things you thought of, John, that you wanted to get out there for people to be aware of?
I had one other case that I thought was really interesting, and it's in this landlord-tenant space. So after 9/11, there was that, which was obviously a force majeure type event. It turned out Cantor Fitzgerald, which was in the World Trade Center, had prepaid their rent. They had a front-loaded lease in which they paid a bunch at the front for certain concessions from the landlord.
Okay.
And so, to boil down the case, basically they wanted to get the money back, because they said, we paid a bunch up front, and you're not able to provide the property because the property is gone. So we can't go there. So you need to give us this money back. And the lease had a provision that the landlord, the Port Authority, wouldn't be liable for any failure, delay, or interruption in performing its obligations due to causes beyond its control, force majeure event, and causes or conditions beyond the control of the Port Authority means acts of God, war, acts of third parties for which the Port Authority is not responsible, which would be the attacks. And there, because of that clause, the court found that the defendants are sophisticated commercial tenants. There's no reason to excuse them from operation of the force majeure clause, which they freely negotiated. They bargained away their right to hold the lesser liable for non-performance. And so in that case, the Port Authority didn't have to give the money back.
Wow.
They said because of the force majeure clause, which was in favor of the landlord, that said, there's this event, we don't have to perform anymore.
Mm-hmm.
They didn't have to give them the money back.
Yeah.
So
Well, it shows both sides of it,
yeah, it really does. So you really have to be careful, and look at these clauses.
Good. Well, John, as always, you are a wealth of knowledge and help. What if people want to get a hold of you or Egerton? What's the best route to direct people?
Well, our website is www.emlaw.com.
Okay.
And my email address, you're welcome to email me directly, is jwood@emlaw.com. So if you have any questions about this or anything else, welcome to just give me a shout.
Awesome. Well, thanks for everything you do. Thanks for helping to protect our organization and others, and appreciate you.
Yeah, thank you. This is great.
I'm going to stop recording, and then we can chat for just a second.
Okay.